Okay. Are you in? All right, so meanwhile, we're waiting for you. I'm going to start reading jury instructions. So, ladies and gentlemen of the jury, now that you've been sworn, you have taken an oath to serve as jurors in this trial. And before we begin, I'm going to tell you a little bit about the rules of law that will apply to this case and let you know what you can expect as the trial proceeds. It is my intention to give you some of the rules of law, but it may be that I will not know for sure all of the laws that will apply to this case until all the evidence is presented. However, I can anticipate most of the law and give it to you at the beginning of trial so that you will better understand what to be looking for when the evidence is presented. If I later decide that different or additional law applies to the case, then I will tell you. And in any event, at the end of the evidence, I will give you final instructions. You will actually receive copies of those jury instructions with you when you go into the jury room. And those are the final instructions on which you must base your verdict. At that time, you will have a complete set again of the written instructions, so you do not have to memorize what I'm about to tell you. Okay. Again, this is a civil trial. A civil trial is different from a criminal case where a defendant is charged by the state prosecutor with committing a crime. The subject of a civil trial is a disagreement between people or companies where the claims of one or more of those parties has been brought to court to be resolved. It can also be called the trial of a lawsuit. In this trial, the plaintiff, Lois Yount, as personal representative of the state of her husband, Leo Yount, is filed against defendant R.J. Reynolds Tobacco Company. Lois Yount alleges that her husband died as a result of misconduct by R.J. Reynolds, other tobacco companies, and tobacco industry organizations. Lois Yount also alleges that her husband was addicted to cigarettes manufactured by R.J. Reynolds and its predecessor companies, and that such addiction was a legal cause of Mr. Yount's lung cancer and death. This lawsuit stems from a case that was filed in Miami-Dade County, which is known as the Engel class action. The Engel class action was brought on behalf of Florida citizens and residents who were alleged to have been injured by addiction to cigarettes containing nicotine and otherwise by the misconduct of certain tobacco companies and tobacco industry organizations. The Engel defendant tobacco companies are R.J. Reynolds Tobacco Company, Philip Morris USA Inc., Laura Lard Tobacco Company, Brown and Williamson Tobacco Corporation, and American Tobacco Company. The Engel defendant tobacco industry organizations are the Council for Tobacco Research USA Inc. and the Tobacco Institute Incorporated. If Leo Yount was a member of the Engel class, certain findings by a jury in the class action, the Engel case, will be binding on the defendant in this case. Class membership is established if the plaintiff proves by the greater weight of the evidence that Mr. Yount was addicted to cigarettes containing nicotine, and if so, that such addiction was a legal cause of his lung cancer and death. First, smoking cigarettes causes aortic aneurysm, bladder cancer, cerebrovascular disease, cervical cancer, chronic obstructive pulmonary disease, coronary heart disease, esophageal cancer, kidney cancer, laryngeal cancer, lung cancer, specifically adenocarcinoma, large cell carcinoma, small cell carcinoma, and squamous cell carcinoma. Also, complications of pregnancy, oral cavity or tongue cancer, pancreatic cancer, peripheral vascular disease, pharyngeal cancer, and stomach cancer. Second, cigarettes that contain nicotine are addictive. Third, the Engel defendant tobacco companies placed cigarettes on the market that were defective and unreasonably dangerous. Fourth, the Engel defendant tobacco companies were negligent. Fifth, the Engel Defendant Tobacco Companies and the Engel Defendant Tobacco Industry Organizations concealed or omitted material information not otherwise known or available, knowing the material was false and misleading, or failed to disclose a material fact concerning or proving the health effects and or addictive nature of smoking cigarettes. Carlos, if you give me your email address, I'll send a link with the invitation. Maybe that will help. 6, the Engel Defendant Tobacco Companies and the Engel Defendant Tobacco Industry Organizations entered into an agreement to conceal or omit information regarding the health effects of cigarette smoking or the addictive nature of smoking cigarettes, with the intention that smokers and members of the public rely to their detriment. Throughout the trial of this case, you will receive additional instructions from the court regarding these Engel findings. Lois Yount alleges that Leo Yount was addicted to cigarettes manufactured by R.J. Reynolds and its predecessor. Oh, it's a cites issue? Give me one sec. Let me try this, okay? And maybe this will help. Not sure where I left off. 6, the Engel defendant, what? Did I read the 6th factor? Okay. 6, the Engel Tobacco Companies and the Engel Defendant Tobacco Industry Organizations entered into an agreement to conceal or omit information regarding the health effects of cigarette smoking or the addictive nature of smoking cigarettes, with the intention that smokers and members of the public rely to their detriment. Again, you're going to receive instructions on these Engel findings, as I explained during jury selection throughout the trial. Lois Yount alleges that Leo Yount was addicted to cigarettes manufactured by R.J. Reynolds and its predecessor companies, and such addiction was a legal cause of Mr. Yount's lung cancer and death. She also alleges that R.J. Reynolds and its predecessor companies concealed or omitted material information not otherwise known or available, knowing that the material was false and misleading, or failed to disclose a material fact concerning the health effects and or addictive nature of smoking cigarettes. Mrs. Yount also alleges that the defendant R.J. Reynolds entered into an agreement with the other Engel Defendant Tobacco Companies and the Engel Defendant Tobacco Industry Organizations to conceal or omit information regarding the health effects of cigarette smoking or the addictive nature of smoking cigarettes, with the intention that smokers and members of the public rely to their detriment. She alleges that as a direct and proximate result of this misconduct, Mr. Yount smoked cigarettes manufactured by R.J. Reynolds and its predecessor companies, developed lung cancer, and died. Plaintiff accepts that in combination with the wrongful acts of defendant and other tobacco companies, Mr. Yount bears some measure of fault relating to the frequency and duration of his efforts to quit smoking. R.J. Reynolds denies all of plaintiff's allegations and also alleges that Mr. Yount was himself at fault. Weighing the evidence. In deciding this case, it is your duty as jurors to decide the issues and only those issues that I submit for your determination. You must come to an agreement about what your answers will be. Your agreed upon answers to my questions are called your jury verdict. The evidence in this case consists or will consist of the testimony, sworn testimony of the witnesses, all exhibits which will be received in evidence, and all facts that may be admitted or agreed to by the parties. In reaching your verdict, you must think about and weigh the testimony and any documents, photographs, or other material that will be received in evidence. You may also consider any facts which might be admitted or agreed to by the lawyers. Your job is to determine what the facts are. You may use reason or common sense to reach conclusions. You may draw reasonable inferences from the evidence, but you should not guess about things that were not covered here and you must always apply the law as I have explained it to you and will again explain to you. Carlos, you just need to put your camera on. So I'm going to give you a little bit of an explanation, perfect, as to the trial procedure. Now that you've heard a little bit of the law, let me let you know what you can expect as the trial moves forward. When I'm finished giving you these instructions, I'm going to ask you to step outside briefly while we can do a little bit of legal housekeeping, getting the case ready to go. And when you come back in, the attorneys are going to make what is called an opening statement. Each attorney has the opportunity to make an opening statement. And in an opening statement, the attorney is allowed to give you his or her views about what the evidence will be in the trial and what you're likely to see and hear during the testimony. After the attorney's opening statements, the plaintiffs will bring their witnesses and evidence to you. Evidence is the information that the law allows you to see or hear in deciding this case. And evidence includes the testimony of witnesses, documents, and anything else that I instruct you to consider. A witness is a person who takes an oath to tell the truth and then answers attorney's questions for the jury. The answering of an attorney's questions by witnesses is called giving testimony. Testimony means statements that are made when someone has sworn an oath to tell the truth. The plaintiff's lawyer will normally ask the witness the questions first. That is called direct examination. Then the defense lawyer may ask the same witness additional questions about whatever the witness has testified to. That is called cross-examination. Certain documents or other evidence may also be shown to you during direct or cross-examination. After the plaintiff's witnesses have testified, the defendant will have the opportunity to put witnesses on the stand and go through the same process. Then the plaintiff's lawyer gets to do cross-examination. The process is designed to be fair to both sides. It is important that you remember that testimony comes from witnesses. The attorneys do not give testimony, and they are not themselves witnesses. Objections. So sometimes the attorneys will disagree about the rules for trial procedure when a question is asked of a witness. When that happens, one of the lawyers may say objection. They may make an objection. The rules for a trial can be complicated, and there are many reasons for an attorney to object. You should simply wait for me to decide how to proceed. And if I say an objection is sustained, that means the witness cannot answer the question. If I say an objection is overruled, that means the witness will answer the question. When there is an objection and I make a decision, you must not assume from that decision that I have any particular opinion other than that the rules for conducting a trial are being correctly followed. If I say a question may not be asked or may not be answered, you must not try to guess what the answer might have been. That's against our rules too. So sidebar conferences. Sometimes I will need to speak to attorneys about legal elements of the case that are not appropriate for the jury to hear. The attorneys and I will try to have as few of these conferences as possible while you are giving us your valuable time in the courtroom. But if we have to have such a conference during testimony, we will try to hold the conference until, as I explained, under these pandemic protocols that I have to operate under, we're going to just step outside and have brief conferences and come back in, which actually will take a bit less time than excusing the jury every time that we have to have a more extensive discussion on legal matters. We'll try to have as few of those as possible so we make the most of your time in the courtroom. Breaks in a trial are called recesses. During a recess, you still have your duties as a juror and must follow the rules. Even while having coffee, you're at lunch, or you're at home overnight. After all the evidence is presented to you, I will instruct you on the law that you must follow. It is important that you remember those instructions to assist you in evaluating the final attorney presentations, which are called closing argument, and later during your deliberations to help you correctly sort through the evidence to reach your decision. The attorneys will then have the opportunity to make their final presentations to you, which are called closing arguments. And after closing arguments, I'll give you final instructions on the law, as well as instruct you on procedures you must follow to decide the case. After final jury instructions, my bailiff will escort you to the jury room to discuss and decide the questions I put on a verdict form. You will have a copy of the jury instructions to use during your deliberations. The discussions you have and the decisions you make are called jury deliberations. Your deliberations are absolutely private. Neither I nor anyone else can be with you in the jury room. When you finish answering the questions, you will give your verdict form to the bailiff. We all return to the courtroom where your verdict will be read. And when that's completed, you will be released from your assignment as a juror. Finally, before we begin the trial, I want to give you a brief explanation of rules you must follow as the case proceeds. Keeping an open mind. You must pay close attention to the testimony and other evidence as it comes in during this trial. However, you must avoid forming any final opinion or telling anyone else your views on the case until you begin your deliberations. This rule requires you to keep an open mind until you have heard all of the evidence and is designed to prevent you from influencing how your fellow jurors think until they have heard all the evidence and have had an opportunity to form their own opinions. The time and place for coming to your final opinions and speaking about them with your fellow jurors is during deliberations in the jury room. After all the evidence has been presented, closing arguments have been made, and I've instructed you on the law. It is important that you hear all of the facts and that you hear the law and how to apply it before you start deciding anything. It is the things you hear and see inside this courtroom that matter in this trial. The law tells us that a juror can consider only the testimony and other evidence that all the other jurors have also heard and seen in the presence of the judge and the lawyers. Doing anything else is wrong and is against the law. That means that you must not do any work or investigation on your own about the case. You must not obtain any information about the case or anyone involved in the case from any source whatsoever, which includes reading newspapers, watching television, or using a computer, cell phone, any electronic device, the internet, or any means at all to get information related to this case or the people and places involved. And that applies, again, when you're in the courthouse, when you're on a break, when you're at home, when you're out to lunch, overnight, on a recess. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place that is discussed during the trial. Do not provide any information about the case to anyone, including friends or family members. And don't let anyone, including your closest family members, make comments or ask questions about the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So don't let even your closest family members, and they're going to be curious about this, but don't let them ask questions or make comments to you about the trial. And I want to add, in this age of electronic communication, just as you must not talk about the case face-to-face, you must not talk about the case by using an electronic device. So you must not use phones, tablets, computers, or other electronic devices to communicate. Do not send or accept any message related to this case or your jury service. Do not discuss the case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. So while we're in recess, don't discuss anything about the trial or the case with each other or with anyone else. If attorneys approach you, don't speak to them. The law says that they are to avoid contact with you. If an attorney will not look at you or speak to you, please don't be offended or form a conclusion about that behavior. The attorney is under my rules, and the attorneys are under an order from me, and the law says that they are not to have any contact with you outside the courtroom, so they're just following the law. Please don't think that they're being rude or impolite. That's not the case. So if an attorney or anyone does try to speak with you or says something about the case in your presence, please inform the bailiff immediately so he can bring it to my attention. Only you get to deliberate and answer the verdict questions at the end of the trial. I will not intrude into your deliberations at all. I am required to be neutral. You should not assume that I prefer one decision over another. You should not try to guess what my opinion is about any part of the case. It would be wrong for you to conclude that anything I say or do means I'm for one side or another during the trial. Discussing and deciding the facts is your job alone. So cell phones, all cell phones and other types of electronic devices must be turned off while you're in the courtroom. Turned off means that it's actually off. It's not in silent or vibrating mode. You may use electronic devices during recesses. However, again, not to use them. You're still under an order not to use them to communicate about the case, no research on the case, no sending or receiving messages regarding the case or the people and places involved. Do not take photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. After each recess, please double check to make sure your device is turned off. At the end of the case, while you're deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If there are breaks in deliberations, I may allow you to communicate with your family and friends, but don't communicate about the case or your deliberations. And if someone needs to contact you in an emergency, then we're not there yet. But at the conclusion of the trial, when you actually go to deliberate, my JA stands by. You'll have her number. Your loved ones can have her number. Anything at all happens where anyone needs to contact you, they can call her, and we will break deliberations to allow you to take care of anything that might occur while you're in the jury room. Okay. So with that, in an emergency, we have a way to make sure that you can be contacted. The court's phone number will be provided to you. Finally, note taking. We need to retrieve notepads and pens from my office, which will be given to you before opening statement. If you want to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you don't want to. That's completely up to you. You will be provided with a notepad and pen for your use if you want to take notes. However, any notes you take are for your personal use, but they are not to be taken outside the courtroom. So during recesses, I'm either going to say to you, please leave your notepads on your chair, or my bailiff will collect them every time that we take a recess, and then he or she will return them to you when you come back in. So when you get your notepad from my bailiff, I'm just going to ask you, on page 1 of the notepad, just write your name, and then our bailiff knows who to give it back to. Okay. If after you complete your deliberations, the bailiff delivers the notes to me, they are destroyed. Nobody will ever read your notes. If you do take notes, please don't get so involved in note taking that you become distracted from the proceedings. Your notes are merely aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the case. So we may reach the point this afternoon where the plaintiff begins bringing witnesses to you. During witness testimony, you may, live witness testimony, you may have a question that you believe should be asked of a live witness. If so, we have a procedure that we follow to address any questions that you may have. If you have a question that you believe needs to be asked, after all the attorneys have completed their questioning, if you recall, the plaintiff will have direct examination, and then the defendant will have cross-examination. The plaintiff may have redirect examination. Then I will ask you, do any members of the jury have a question that you wish to be asked of this witness? And then I will ask, if you do, you don't speak it out loud, you write it down on a piece of paper and hand it to the bailiff. The bailiff will walk it to me. I will go outside with the lawyers and discuss the question. Any question that is asked of a witness needs to be under our rules, under our laws in Florida. So the attorney's questions have to be under our laws, and the jurors' questions are bound by the same laws. So if your question may be asked under Florida law, then I'll read your question verbatim, just as it's written to the witness, and the witness will answer. The attorneys may have some follow-up questions if they wish, based on any question that members of the jury ask. And then we'll go through it all over again. I'll say, are there any other questions that the members of the jury have? And we just go through that procedure. But by telling you this procedure, I don't mean to suggest that you should or must ask questions, because in most cases, the attorneys will ask all the necessary questions. So with that, we are ready for opening statement. But again, there's some, I call it legal housekeeping. As I explained to you in the beginning, I'm the judge of the law. I have to make sure that everything proceeds under Florida law and Florida rules. And that's not a matter for the jury to hear. So whenever we have an issue of law, that's when I have to talk to the lawyers. And either we will do it by us stepping outside, or I'm going to ask the jury to step outside while we take care of those issues. So we do have some issues right now. This is a good opportunity for you to use the restroom, stretch your legs, because opening statement, I think, is going to take a couple hours. So Carlos will tell you where to use the facilities, and we're going to take about a 15-minute break, and then we'll be ready to go. Okay? Thank you. One moment. Sure, yeah, absolutely. Okay, are we ready? Because I don't want to leave them out there forever. And didn't I say we were going to do this at 7 a.m. on the day that we do opening statement? I mean, I can always just reinstate Judge Miller's order and then we're ready to go. So it behooves both of you to agree on as much as you can. Okay. Okay.
First objection to slide 7.
Okay. Uh-huh.
This is an objection that we sort of carried through a couple of different slides. And my objection is that this chart that's a document that we excluded before it trial. That document is not coming up with any foundation. This paper in the first trial, this was a reading in the first trial.
Okay. All right, what's your argument, please?
The argument is, that this can't be based on.
Is there any evidence about, and just for the record, this is a graph that shows the rise of lung cancer over the years, peaking in the 80s and then on a steep decline thereafter. So is there any testimony that's going to support these facts? And is there any objection to any of that testimony? Well, it depends. Is anyone going to be testifying? Is any testimony coming in? Cigarettes smoked in the USA per billion and male and female lung cancer rates. So regardless of whether the Surgeon General's report is coming in, the historian is going to be testifying about the rates of lung cancer among men and women through the years. I'm not, was there a motion limiting to exclude the Surgeon General's report in this case? So what is the foundation for his testimony to avoid an objection? What is the foundation of his testimony on the rates of lung cancer over the years as a result of smoking cigarettes? What is he basing it on? I mean, I would, regardless of this, the Surgeon General's report may report, epidemial results of lung cancer, but those are independent facts. The rates of lung cancer, are they not coming in this case, that the historian cannot testify that lung cancer rates spiked at a certain point and kept going up while certain, statements or omissions were being made by RJ Reynolds?
So this, some of that information.
Okay.
Some of the historical.
So the chart is, the chart may or may not come in. I could certainly instruct them that these exhibits are not in evidence, they're being used as demonstratives. Okay, so the testimony the jury's going to hear is about lung cancer rates, how the rates increased at a certain point and began a steep decline. That might coincide with warnings and, stuff like that, might come in through both sides. So this would be a demonstrative to that. No one's mentioning the Surgeon General's report or its conclusions. Is that okay? So your objection to that is overruled then.
Okay, and that's just for the record, that objection is extended to slide 18.
Okay,
Similar.
all right. And anything else?
Yeah, and there's another chart on slide 27, which helps.
All right, but my understanding is that the Surgeon General's reports are not coming in because they are hearsay. Okay. Any other objection?
Yes, ma'am. An objection to slide 9.
Okay.
Objection to sort of support. And the second objection is that slide really, I don't really understand the relevance of this slide because they're playing on fraud that the company is doing. Knew about the dangers. If that's the basis of the claim, what was coming into our realm from the public really doesn't count. I don't really understand the point of the slide, but my main objection is to
Well, I don't know if it's argument or not. I mean, I don't know what the testimony is going to be coming. What are you saying in opening to correspond with this slide?
No, from our research, peer review research, and all this information will be shared.
Okay, so long as it's not stated in an argumentative fashion, that it's stated in a, here's the evidence on the concealment claim, I'll overrule it.
Your Honor, next is just for the record, that objection is the same slide. Same slide, same objection.
Okay,
But the next objection, Your Honor, is the next slide, subsequent 6.
Yeah.
We start our. Okay, Your Honor, this is, they made a small change to this, added the word made in that header, but I still think the header here is. If they want to talk about the evidence, they could change it to not. That's just the evidence. But what they're doing here is arguing. It's going to be trying to undermine strong.
I don't know that I understand your argument.
It's just an argument for being sensitive to our mission that we are playing.
Well, the defense is, in this case, is that Mr. Yount chose to smoke because he enjoyed it. We will show you evidence that in one of the hallmarks of addiction is that you suffer when you stop, and you only feel good when you're smoking, and, so long as he's not argumentative, I don't,
And I agree with what you said.
Right.
That's why I think that, I think that Mr. Young feels that is what the running out of this change.
okay, so can you just put Mr. Yao may appear to enjoy smoking? Well, then that's fine. He doesn't have an objection to the content, just the header. But that's him, right? Okay, just change the heading. I'm not going to spend an hour on these exhibits that really should have been exchanged and worked on hours and hours ago and take jury time. And I've warned you all of this. So just change the heading. Mr. Yan appears to enjoy smoking. What's next? Okay, that's fine.
Your next is slide 35.
No, the quotes speak for themselves, do they not? And they're part of the evidence?
I agree, which is why.
Okay, it's overruled.
One more. Slide 32. Objections to reference to the industry spending $250 billion a month on cigarettes. That data that's
All right, do you have any foundation for the monetary amount? Right, but I have to be careful that it's not just a conduit for hearsay, just based on him, reading hearsay documents and repeating them. Okay, well, you could say billions. I don't think anyone,
Yeah, the specific.
All right. So you can say billions, okay? Okay, anything, and that was your last one. And any objections for the plaintiff? Okay, all right. Do I need to see him? That's okay. Okay. And what slides, please? Or I don't have slide numbers, but I have page numbers. And what's the argument? Right.
Initially, for context, if you look at the pages before, all of these slides are addressing the couple pages, are addressing the alliance. And that's important because you know, that is the so our initial concern is when we get to this slide, after a number of slides, they're talking about the intentional occurrence. On these 5 bullet points, machines you'll need to report. The first one says that you have not started smoking because of anything wrong with your friend because you said it did. And remember, the saying is what the actual report is.
But there still needs to be reliance. If there's concealment and no reliance. Right, okay.
If you look at the next bullet point, I'm making clear to you that that also relates to the intentional force and concealment. So that is Mr. Young understood the danger of smoking and time to put it in a brief one hand. That's their argument for breaking the causation chain, saying the concealment by them didn't matter to Mr. Young, because he already knew what they concealed. The next bullet point, Mr. Young was surrounded by warnings about the danger of smoking. That's it again, arguing to break the chain.
Or it's reliance on lack of reliance.
Which is all okay, but now there's my concern. The last two bullet points are addressing comparative negligence. Comparative negligence does not apply to the intentional force. It's not a law and the decision that there was the famous part one and the 40th show, SHOFF, and also by the very language of our admission. So remember that we partially admit false consideration. So by both, and when we do so, excuse me, we make clear we're only admitting as to negligence, liability, not fraudulent. So our first concern is that these two bullets.
Well, let me ask Mr. Bassett, what is it that you were saying in opening that corresponds to this slide?
Well, yes, so Your Honor, first off, it does actually correspond with that discussion of claims. It actually corresponds with the summary of the facts that we expect to present. And so each of these is a way to summarize how we expect the facts to present and not, and issue the jury to decide, which includes class membership, includes subject claims. The last two bullet points that I understand is a concern over. The first one simply, that is the factual admission that forms the premise of the legal admission of partial fault. So
Right, the concern that she has is that there's sort of an amorphous or blended attempt to have his failure to quit excuse fault on the part of R.J. Reynolds for the purpose of fraudulent concealment. Because that's what you're talking about is why he, what did he rely upon, the whole reliance issue? No?
It doesn't have to do with the law.
Okay.
What it does
Okay.
have to do with is when it comes to the overall case, including this issue of addiction causation, was the addiction a substantial contributing cause before addiction would not have contained the one cancer that it did? The fact that there's a factual admission that he could try hard enough, should try harder to quit, is itself a fact suggested from the evidence that Mr. Young had tried harder, should have quit, and therefore break that chain of causation. And that's part of the proof claim.
His attempts to quit, you're saying go to whether he was addicted?
It goes to both the question of addiction and the question of addiction causation, or the question of whether that addiction itself was a substantial contributing cause to his one cancer death.
Okay.
Which is the second part of the legal class membership part. That's all that is. In fact, I would guess what I probably should have just said is the statement that Mr. Young was trying hard enough, frequently enough, before he quit smoking in 1991, in the sense that that's all really this is a, from the evidence, with the evidence to show the force of claim was committed that factually, and understanding to their legal addiction.
Okay. So what's your response to them saying that this is not comparative fault facts exclusively, but also to say that his addiction is not the legal cause of his lung cancer and death, but rather his failure to try to quit is the legal cause, the addiction is not a substantial contributing factor. It's his failure to make a good faith attempt to quit. That is the reason why he developed the lung cancer. What, am I saying that wrong?
They admitted that Mr. Young under question admission is far more about all, but you couldn't have put catastrophic.
So there's a couple of responses, and part of what's happening is I'm just going piece by piece with you, and our other objections were kind of highlighted there by the defense on that same point. The way you just phrased it is really helpful. What this is saying is not just the facts you say, And so when you start talking about what we admit, you go to our complaint, you go to the exact language. of our complaint. We don't admit any of this as to the concealment. We are very clear. And so just addressing that, when you look at the slides that you see this, you have, I don't know, 8 pages before, the national TV news in 1955, local newspapers in 1964.
Right.
Talking about warning. All of this is about what Mr. Young knew. It's all dealing with the concealment. And the argument made by the defendants in all of these cases is, okay, we understand it's not that we found class membership, it's moved on to the concealment. We understand that there's a finding that says we and our co-conspirators conceal information. Our argument, so the defendant saying to you is, that didn't matter to this one smoker, because this one smoker already knew. And this one smoker already admitted fault. So, I'm sorry, losing my voice, I'm not used to talking to that. And so it is improper for them to be saying any of that after all of these cases dealing with the reliance count, with the fraudulent concealment. Now we're talking about.
So what I'll say is this, it's not a matter of me striking the slide, but more what your opening is going to say.
Well, I have a second.
Yeah.
correction as well. I'm starting with the first point, that it should not even be on the slide. My second point is, the admissions are wholly incomplete, and take the summary of wholly complete and take our admissions out of context. The critical way is, first of all, they do not acknowledge that the admission relates only to the negligence. And that change. Secondly, they don't acknowledge what the admission actually says, which is that we admit in combination with the content of the defendant. It's not an all-out admission. There's no factual basis to make it one-sided admission.
Yeah,
And then if you look at the, I'm sorry.
Go ahead.
Okay. And if you even look at the jury instructions that were given in the last trial, they're not tracking that. The admission was simply his failure to try alternate medical part of that.
look, this is not argument, okay? If the defense intends to say, Mr. Yount did not try hard enough to quit, that is evidence that the jury is going to hear. It doesn't have to fit in with the language in the complaint. It doesn't have to fit in with the jury instructions. It doesn't have to fit in with the particular count, because we are not arguing the case at this point. This is recounting what the evidence is going to show. And if your opening is, follows the law on proper opening, you will not pull an objection. If your opening suggests or argues to the jury that his admission somehow wipes out liability on the intentional torts, you will pull an objection and an instruction to the jury to disregard what you say. That's the best I think I can do.
And Your Honor, I fully understand, Your Honor, rule in this part of the discussion we had. Your trial motion. This discussion we're having is all about summary of what actual aspect of this.
All right, but be careful, because if they reasonably suggest or argue to the jury that that Reynolds is without fault because he admitted he didn't try hard enough to quit across the board, there will be sustaining the objection, instructing the jury that they haven't heard the instructions on the claims that are being brought right now, that his admission may go to certain claims and not others. I mean, it could just take quite a bit of steam out of your opening to have that kind of an interruption. Okay. Anything else from the plaintiff?
No, I'm just one more. And there's a couple others with the same thing, but I think the same. I will object, and not at once.
Or doesn't argue it? Okay.
And then the last one is on 15. There was a plaintiff must prove.
Where? No. Oh, there we go. Yeah, that's a legal argument. Well, how about we strike it because it's legal argument? Okay. It's not enumerated that I can see, but it's the upper left-hand side on page 15. Yeah, if you can just strike that board, because it appears to me to be legal argument. Okay? All right, so I think we're ready. Are we ready? The only thing I need to check, Carlos, I never, we didn't prepare notepads. Oh, they do. Thank you. Thank you. Thank you. Sure.
And then your slides or my slides that go off on the screen, hard copy as well, or is that fine?
Oh, you mean this screen over here?
Yeah.
Oh, that's great. No, I do not need any more hard copies. I'll just turn this one.
Your Honor, got one clarification on your last.
Sure.
Is the problem with that heading of the font?
No, if you're going to sit there and say these, your plaintiffs must prove, and I'm reading the jury instructions and you're arguing, that's not the point of opening statement. The point of opening statement is the evidence is going to show this. And if if there's a, that they're going to be unable to, you could say they're unable to meet their burden of proof and you're going to find for the defendant, but please try to avoid making unnecessary argument. Okay. Okay, and I would rather not get into what is or is not a correct statement of law when we're talking about opening statement.
That's just a different issue.
Do we have counsel listening?
I already talked to.
Oh, okay. Can you meet? Hang on one second. Okay, we're ready to go. They're just using the restroom, and then we're going to come into opening right now.
I just wanted to-
Yes.
We reached the deal on that.
Okay,
We see if it's on the record about it before it'll take just a minute.
okay. Well, we have a minute now if you want to put something on the
Well, I
record.
think
Go.
it's sufficient. I just wanted.
All right.
to know that we had-
But I'm not, we don't, it doesn't have to be before opening, so, right?
Well, the one part is. I don't want to waive my objection. I have a motion, you're not ruling the motion, but not also you want to see the specific. document.
Right.
And so.
BLILEY.
Based on your Honor's ruling, I understand that,
I'm going to have to see them before they come in.
right, and I also think that Your Honor might see them before open statement.
Okay, anyone want to show them to me while I'm sitting here?
I'll pull it.
All right,
Now,
okay. Talking about Bliley documents, are you showing or referring to the contents of Bliley documents, the admissibility of which I have not yet ruled on? Okay, so why do I have to deal with this right now?
I believe there are some.
Are there? Oh,
With the understanding that this is already been.
no, I haven't ruled on them yet.
This is my concern.
But I need to see what we're talking about. And to be quite honest with you, sitting here right now, I'm not even sure what the objection was.
It's a privilege.
Didn't I rule on that?
You ruled in a categorical way on it, that our motion to exclude them based on privilege was denied. But you also asked to see them before they were used. And so I don't want to be, Your Honor, I do not want to be the lawyer who waives this privilege.
All right, well, let me take a look at whatever documents agreed subject to privilege are going to be
Your
used.
Honor just wants to overrule my objection. That's fine.
Well, let me see what we're talking about here. It would be helpful to me.
Here's the first one, Your Honor. This is 2201525.
And I think part of my ruling on this was that they have been in the public domain because of multiple objections made in multiple cases, multiple tobacco cases, and then for whatever reason, never advanced on appeal, on verdicts, contrary to this defendant, never argued on appeal, dropped on appeal. And so once they're dropped on appeal, they're kind of in the domain. There's never been a final ruling, you know, that somehow the defendant has maintained their privilege despite losing this argument in multiple cases and never defending it on appeal or advancing it on appeal, to have any final determination of privilege. So privilege is maintained and yet not maintained over the course of decades. So I guess that was not my only basis for ruling, but that was a rather confusing point for me, is that how you can pick and choose when and how you're going to maintain your privilege over documents that were required to be disclosed by Congress, you know, and when such privilege is waived. So I'm looking at PT 1525, September 2nd, 1987. I think I ruled on it. I think I wanted to see the documents before they come in, which I can. So I think your objection is preserved. I'm not going to, you know, that you're preserving your objection, you're putting it on the record, and I think we can go forward. Okay.
You want to see the rest of them also?
I don't think I need to see them right now.
Can I just read these?
Sure.
The exhibits we're talking about would be P201525, P201867, P01913, P02027, P02268, P02286, the rest of the Wiley documents on plaintiff's list. So I assume that you're on doing all those documents.
Will be consistent. Yes.
Certainly that. Some of the documents.
Okay.
And so if you want copies of all these documents, you don't feel like it's an hour
Later, because I will, here, I don't know whose this was.
That's fine.
I'm not great with actual paper, so, all right, thank you.
Your Honor, just so you know, you're not surprised when they use it, I think leave it down for a modification. So they point that in mind.
Okay, okay, okay.
We have a similar issue with all these market documents. We understand you aren't voting not on mission.
On what?
These marketing documents. We understand you aren't as not on mission on that basis. And we agree that some of them will come in over our objection.
Okay, but your objection is not being waived. You're preserving your objection. My ruling hasn't changed, and you do not have to make, when it's shown on the screen in opening, you do not need to make a contemporaneous objection, but you should when the evidence is being offered.
Okay, we'll say something like no further objection.
Right, subject to our objections, or we renew our objection, something along those lines, so that you're sure that you make your record.
Okay, so the one that wants to have it, they will take no further objection.
Something.
Right.
And just so the record is clear, some of the things that they're claiming, marketing approaches, documents, descriptions, asking what it is, the dialogue, and that's clear.
All right, anything else?
Either they no further objection, Wiley, or no further objection. Just so the record is clear.
All right, I'd like to go. Can we go? Are we ready? Yes, let's bring the jury in. Thank you. No, let's get the jury. Yeah. All right, so I think the place in the courtroom they're best able to see the screen is on my left-hand side, right?
I got it. Yes.
So, yeah, so the jury is all going to be sitting over there. how are you examining your witnesses with the jury over there? I mean, we'll figure it out, but how are you?
Yeah, that's a little, that was my only concern here, no way over there. I don't know, there's something, that's something that's closer, moving with it closer.
No, I'm not putting a
Or
witness there.
maybe even here you are.
I'm not comfortable with that. But you may want to swivel your podium a little bit closer to the witness
Yeah.
for your benefit. Okay? In a week, everything can be changed. But we're ready. We're still under, you can still request social distancing, which I must accommodate. So I will, actually, so Loretta, oh, you're getting your stuff. Yeah, we're gonna put all the members of the jury here so that you can see there's a big screen here that they're gonna be showing some stuff to you. I think so. This is what we've been doing in the other trials, right? Yeah, I don't really think I can start monkeying around with moving witnesses to the floor. Oh, you haven't? This is my third. All right, folks, please have a seat. Let me just make sure, can you all hear me? Okay, wonderful. All right, so the attorneys, as I explained before, will now be presenting their opening statements. Whenever you're ready.
my opinion, not what we do. People, guys, and the music, that. It's like something executive, something back in the industry you will hear about. These people, this will finally talk about public contact and what they do. Now, 90% of all smokers in Kansas smoke in their 50%. Heroin, homicide, suicide, car crashes, fire, walking wrong. We're going to put the death about 500,000 murders every year. But who knows what's coming to it now? That is not the case where we go down to the work for 7 years and we go down to the thousands of archival this first time. And evidence is based how we feel, how we can in America, or how we live in America. The evidence is based over 20 years ago. There were only 120 the entire world. That's the doctor, you call it college, you call it evidence, but you don't have a feeling. That's not the case. How do we go from where there are only 140 cases going on in the world? So, that is why the zero starts on popular level. Well, what happens first is the first note that first is that it was popular zero. I would say that. They were like, summer school starts, all high school, prep school, are finished. That's why these schools are. This thing, all the about is. Because the actual real count is still boy. They have 5% chance of and we also look at the plate now, low. Not so that little, no power, that's and those are that we must be somehow. You're actually why you should fight local. But hopefully people will self and discover the real satisfaction. So, generation, what would you actually be the way to do it? You can't do what we look for, or look back to why? And so, here is some of the advertising, 30s, 40s, and 50s. So we use athletes, like Eric Robinson, DiMaggio, the Gary, big movies, the advertising. John Lee, Derek Cooper, Terry Grant, they have advertising no doctors, no camels, and any other cigarettes. And you can advertise the chance to the doctors that can do it. And all we are also they have something to want to know. By the time the deal was over, that in 1930, another time, that in 1939, that's time we learned to be already regular, the L over the white. They were going to be like a capital company, that is talking about credit company, so now, follow the the advertising you'll see where they use it promote it on wall and what the advertising uses it. So that you know now he was a lifelong soldier of the small theater. In 1924, married. First. And so you have to understand how totally wrong it was when we talk about whether I mean, that is not going
Overall.
back to 30, 20, 50. So, the hospital, number one advertisers, sponsor shows, what is basically part of the debt, and we want to do Not an exact, that is something almost terrible. Still, that was very administration itself. It's hard to hold it. So all year round, you know, to come forward, or to get the and the practice, it's certain go through the regulation, water quality answer, that is certain responsibility, paramount, every other consideration of business, and opportunity.
Overruled. Again, ladies and gentlemen, the point of opening statement is what the attorneys believe the evidence will show. It's not the presentation of evidence at this point. It's just their placing slides in front of you right now as demonstrative aids. These are not evidence in the case yet, to show you what they believe that the evidence will show. You may proceed.
So you see, there's a newspaper, magazine, want to focus to is what Mark was writing. Is very and very effective. You must discover the psychological cost and self-rationality to the component. That's what it's most important to make it possible. They believe in trust, rationality, not so the same kind of part of the personality is level to it. Now, they will take actually the sure, we never touch it.
Overall.
And maybe that you'll find it. So we are making the ball, what we're saying is, it was about using the therapy, not what you're labeled around here at that time. That is that label that is doing general working favor to the house. We were at very well. Work, that's fine. Now, start to do forward, long still, and I'm starting to get a problem with that. Wow. On two closes, for an older partnership, we just have to build a life. Here, now, Lines are, the blue line is the total consumption, and the red line is the per capita consumption. And although the exact peak of the per capita consumption is 1964, total per capita total consumption includes per capita 70 and 80. Total consumption goes to 200. And then the per capita total consumption, those lines are going down. And so this is now your specify. If you have this back company, it's important. So this is now have an opportunity to prove that the gap will be out of tax. We are the new company. Many decades. The gap will be out of tax. And so the rate that you need is about. We are the field now with providing a strong private site. And now, so it's good that everybody's good. The family members, later is the wall. For time, where it did not, be able to be aware. Sometimes that's how we're elbow, tattoo, or not next. However, did not reveal it to them, conceal it, and people that fit how do we exactly the street for and right and right and very consumers are aware of that entity existing. And so while this is going on our like this, still under wild doesn't occur naturally in the background, there is no data. That would be how we manipulate it. They were going to manipulate very precisely, certified. Certified would make more helpful. Certified prior level of management. So although this does occur naturally,
That's overruled. Again, ladies and gentlemen, it's the purpose of opening statement is what council believes the evidence will show.
I don't know if any folks who wish to, most of our customers, those are the words that I don't, when we find the deal now, because longer you talk, the greater the difference you imagine, the more difficult it is to fix. Now, usually you consider the lateral as a history as to your parents. There is no overstatement. No, I think the evidence is very clear that you understand what we're talking about. Addiction is a specific physiological problem. And the manner in which you become addicted to nicotine is exactly the same manner in which you become addicted to cocaine. And even after you're at quit, and you think you're coming, there's a tremendous tendency to relapse. There's no such thing as a cigarette.
So even though the amount that she gathered, there was everything, anything that they said was a matter, you know, you was really strong, effective. Now, we have more information, right? More information coming out from different than that. Again, we'll hear about 60 million or there, and it's the NFL defines the smoker. If the person who smokes cigarettes past 7 to 8, the number of new smokers is considered to be overestimated. Start and then like this is another one of the real lasting quit, and that's but you'll learn that there is a lag time, which is in the right spot. Somebody does it. Talk about what we will feel about we hear about the case but all information, all the TV, magazines, all that is available. They also give their own research. They also have total research for the PCR. You'll see the data for the scientific articles, peer review,
Same.
Get it to be, they have all the information they need. If you should have known that your product was for it. So look your mind up to figure out. Where they were required.
This is the house. Mr. He's bringing in there, Steve, Uncle John, Barbie, looking at their brother Tim. Debbie, who soon graduated from high school. Susan, our youngest, and my wife Peggy, who was after all. And that's me, Bill Thorne, who's a friend of mine you might recognize. You know, I don't really mind losing this program battle, but I'm in a battle right now I don't want to lose at all. Because if I lose it, it means losing my wife and this kitchen business. I get lung cancer. But taking advice about smoking and losing from someone who's been doing both for years. If you don't smoke, don't start. If you do smoke, quit. Nothing else.
All the information they need.
Same. It's argument. Okay, well, can we refrain from argument and you can discuss what the evidence will show?
So the board that the evidence the manufacturer has used another product. Document. They were running internally, that's going to be very research, calculate knowledge, that's far more expensive. than what it is to publish on the public access. The overall, we got to look at the smoking manufacturer having to use those products. That would be an opportunity to go organize.
The argument one of those tobacco companies took out this ad in a number of newspapers that was vaccines, calling for an open debate about smoking. In which the ad contends that medical studies which show that cigarette smoking causes disease are ignoring significant evidence to the contrary. Cigarette smoking does not cause cancer, yes or no? It is not known whether cigarettes cause cancer. It has not been causally established. Cigarette smoking, no causal relationship between cigarette smoking and the cigarette. Despite all of the research to date, there has been no causal link established. No causal relationship between cigarette smoking and heart disease. No, as a matter of fact, there are studies that while we are accused of being associated with heart disease, there have been studies conducted over 10 years that would say again that science is still puzzled over these forces. you know, legally, this is not legally. I think everything is already there. Mr. John, Congressman, cigarettes and nicotine clearly do not meet the classic definitions of dictionary. No, so we'll take that and again, kind of short. I think each of you believe that you would like to happen to her. I don't believe that nicotine for our products is it. I believe it. I believe that nicotine is not addictive. I believe that nicotine is not addictive. I do believe that.
And so the evidence will be that this is not a few executives based on stupid things. Careful to overstate. The evidence will show what, when you go to an internal document or you young adults know that it's critical, original, long-term performance and profitability. Chemical compound, more critical to the class. All these are jobs, ultimately, going for more money. Whatever the reason, profit, good job. So I want to talk a little bit about how membership and reiterate that told you in this case it's not asking to solve 1990 before it was out. It started flowing in 1930s, 40s, 50s. And the question is whether we are not addicted to the and if so, what such addiction is the usual cause of the one chemical again. The question is one of the questions what is due for every day? In the morning, always wasn't it? The little bit of respect was coming to very well qualified on the issue. Also, we want the person to know one of the key to the knowledge and the doctor.
No, it's overruled at this time.
And on that, before you see that problem, but definition of legal cause, fiction will be talked about legal cause. What is a legal cause? Legal cause. For one thing, that it is directly and natural or considered
Sustained. Just the last part. This was not objected to, the screen up there. Thank you.
and so the evidence would be that nobody, well, judicial has today,
Sustained. Granted. It's sustained. This is legal argument. Okay, that's sustained. Just the last bit. Can I just see counsel here just for 1 second? I don't need the record. We're going to take a lunch break now. It's about 10 minutes of 12. So if you all can be back here on the 6th floor at 1:15, just give you a little bit of time to get somewhere and have a decent lunch. Again, and I'll remind you throughout the trial not to talk to each other about the trial, the people and places involved, your jury service, the issues in this case, or anyone else, not to do any research on your own. You can talk about anything else you like if you all have lunch together, and we'll see you back here at 1:15. Thank you. And please give your notepads to Carlos. Thanks.